It is time for another episode of the Politics with Paul podcast with your host, Paul Rader. That's me. Today we're going to talk about the separation of powers in government. In his first few weeks, Donald Trump and his administration have been moving at a blistering pace to implement his policies, including enacting tariffs and reducing federal spending and government employees. Beyond the debates of whether these policies are harmful or beneficial, however, a new front in the debate over separation of powers in government, how the responsibilities and duties of each branch of government are divided, has been opened up. In the eyes of opponents of Trump, many of the actions by him and his allies, such as Elon Musk, are a serious overstepping of the boundaries of executive branch power. In the eyes of supporters of Trump, he is operating well within his rights and doing what should have been done before. Now, of course, as is typical policy, I'm not here to say if there is a particular side I support and by how much I do support them or don't, but I am here to, as objectively as possible, lay out the arguments that both sides have for why they feel the way they do. So today, we are going to discuss the separation of powers, a key component to our system of government. What it looks like, why we have it, what it means for today's politics, how it closely relates to the concepts of checks and balances, and so on. So, let's get to it. So, first of all, why do we even have a separation of powers? We have three branches of government. We have the executive, which executes or enforces laws. We have the legislative branch, which writes laws, it legislates. And we have the judicial branch, which interprets laws. And these branches of government also extend to the state and local levels of government, though how they look differs from the federal government, and we're really, just for today, focused on the federal government in particular, although you will see some of these similar kinds of debates and concepts be applied to those levels of government as well. But the separation of powers is kind of used interchangeably between or with checks and balances. Checks and balances being the methods by which each branch checks the power of the others so that one branch doesn't get a leg up over the others. So they're technically different concepts, but you can sometimes consider them the same thing. Separation of powers being specifically what duties are given to each branch, and checks and balances being how each branch checks the other. But more or less the same overarching concept. And the concept itself is credited to the 18th century French philosopher Montesquieu. And a lot of governments around the world who implement a similar separation of powers concept, they have Montesquieu to thank for that original concept. And in particular, for the case of the American form of government, we have Federalist Papers numbers 47 to 51 that talk about the separation of powers, how the, at the time, new Constitution kept separation of powers as a thing and why it was fundamental to freedom and good government, and how the new form of government would have or would keep checks and balances in place, why it adhered to those concepts better than what was then the governing document of the United States, the Articles of Confederation. And the Federalist Papers were a series of papers that defended the new Constitution and told people why exactly it was needed to replace the Articles of Confederation. Federalist Papers all written by either Alexander Hamilton, James Madison, or in a few cases, John Jay. And so, again, Federalist Papers 47 to 51, those described separation of powers in the new government. So the whole idea was to prevent excessively concentrated power in one branch. According to James Madison in Federalist 51, prevention of excessively concentrated power, quote, consists in giving to those who administer each department the necessary constitutional means and personal motives to resist encroachments of the others, end quote. So, short answer is that checks and balances, separation of powers, is designed to keep singular entities within the government from deriving too much power. So you think about What if the president could also write laws or make judicial rulings? What would that mean for government function and personal freedoms? What if you had that with judges instead, or with the Speaker of the House being able to execute and enforce laws or make judicial rulings, or for judges to be able to enforce laws or to write laws? So we have different branches of government that relate to those specific functions. Now, the exact functions of each branch and how they have administered their duties, that's somewhat changed over time as new policies have been implemented, branches have gotten bigger, political norms have changed, and so on, but largely the fundamentals of separation of powers haven't changed. Or have they? In some people's eyes, some of that separation of powers, the line between the powers of the branches has been somewhat blurred, and obviously we'll get a little bit more into that soon. But first, what does the separation of powers look like specifically for the executive branch? So at the federal level, we have president, vice president, 15 cabinet departments, and a lot of independent agencies. Cabinet department examples being Defense, Health and Human Services, Interior, Homeland Security, Commerce. Independent agency examples being the Central Intelligence Agency, CIA, the Securities and Exchange Commission, SEC, Federal Trade Commission, Environmental Protection Agency, the Equal Employment Opportunity Commission, National Science Foundation, Small Business Administration. These ones are still technically within the purview of the executive branch, but are considered independent in that the president's power over them, such as the ability to appoint or dismiss members, is more limited than it is with the cabinet departments, though they are still considered executive branch agencies. So, as we said before, the basic duty of the executive branch is to execute/enforce laws. And what does that look like? Well, each cabinet department and independent agency has a specific policy area they handle. So, Department of Commerce handles commerce, Health and Human Services handles health policy, so on and so forth. President, in particular, is the commander-in-chief of the military, picks the heads of the various executive branch agencies, enforces laws by Congress, assuming they weren't vetoed by the president and Congress didn't override the veto, and enforces interpretations of laws by federal courts. Now, checks and balances. How does it check and balance against the legislative branch? The president can veto legislation passed by Congress. He can propose legislation to Congress through the State of the Union, and he can issue executive orders that have the force of law like a congressional law. Although the nature of executive orders, even whether the president is allowed to administer executive orders or how much he has the power to do that, that is a controversial power, which we'll get into later on in this episode. But a check and balance against the judicial branch is that the president appoints federal judges, though with the advice and consent of Congress. Speaking of which, what does separation of powers look like for the legislative branch? So at the federal level, you've got the U.S. House and the U.S. Senate, which are the most obvious ones, but you also have a bunch of special agencies that provide support services to Congress, employees for specific members of Congress, so chiefs of staff, legislative assistants, press secretaries, and so on, and employees for the parties in Congress. Sometimes it might be for the overall parties, overall Democrat and Republican Party in Congress, or they might be for a specific chamber, so specifically for the U.S. House or the U.S. Senate. And as we said earlier, basic duty of the legislative branch is that they legislate/write laws, or in the case of their support staff, they help them research or set up meetings with the president or with lobbyists and so on and so forth. And in Congress, in particular, there's sort of, in a way, a separation of powers within the legislative branch that you don't find in the judicial branch or the executive branch. In Congress, there is what we call bicameralism, which means there's two chambers, the U.S. House and the U.S. Senate. And all state legislatures except Nebraska's also implement that. They just have a state Senate. U.S. Senate has much more of a role in treaties and foreign policy, whereas the U.S. House is where all appropriations, which is another word to say funding, originate. So funding for all sorts of government programs or for states to implement their own programs. All of the funding bills originate from the U.S. House, although an identical bill does need to be passed in the U.S. Senate. But that is, the U.S. House is where appropriations bills originate. And what does the implementation of these duties look like? So there's a general path that laws follow for most things. Again, there's a little bit of a difference when it comes to things like appropriations or treaties or impeachments, but generally speaking, they pass laws through, a bill starts in a committee, it goes to the full chamber, might have to get some things hammered out before the whole chamber passes it, and then the other legislative chamber must pass the exact same bill. Now, exact path for that bill depends on various factors. It might require multiple committees or a subcommittee to deal with it, and that just depends on what the subject area of the policy is, whether it's health or it's economy or guns, all sorts of things. Depending on what the subject area is, it will originate in a different committee than a bill with a totally different subject area will originate in. And then, like we said before, legislative staffers help with the day-to-day operations of Congress, like researching bills, preparing members of Congress for meetings and press, and so on. Now, how do they check and balance against the other two branches? So the legislative branch checks and balances against the executive branch by providing, quote-unquote, advice and consent to the president in appointments and treaties with other countries. They can override the president's veto of legislation with a 2/3 vote by both the U.S. House and the U.S. Senate. So if they pass something, the president says, I don't like that, I'm going to veto it. If enough of the U.S. House and U.S. Senate really back that bill, then they can override that president's veto. It's quite difficult to do, though. With the House specifically, they have the power of the purse, although Senate does have to sign on for an appropriations bill as well. So power of the purse being controlling funding for, in this case, executive agencies. And, of course, they can impeach the president. And we saw several recent instances of that with Donald Trump in his first term, and then back when Bill Clinton was president, there was an impeachment proceeding there. Checks and balances from the legislative branch, or from the legislative branch against the judicial branch, is that they can also impeach federal judges. And judicial nominees still need to be confirmed by Congress in order to take office. And those judicial nominees, let's move on to the judicial branch. What does the separation of powers look like for the judicial branch? So at the federal level, we have the Supreme Court of the United States, or SCOTUS for short. We also have 13 U.S. courts of appeal, 94 U.S. district courts, 90 U.S. bankruptcy courts, and then some specialized courts called Article I courts, which includes courts like the U.S. Tax Court. Most federal judges are called Article III judges because Article III of the Constitution primarily deals with these judges, but these specialized courts are actually established in Article I, and unlike Article III judges, Article I judges actually have a fixed term. I believe it's 15 years, but Article III judges have those lifetime terms. So, as we said before, the basic duty of the judicial branch is to interpret the laws, which is otherwise known as judicial review. So, whenever Congress passes a law or the president administers an executive order or whatever sort of actions government takes, the judicial branch can review those actions to see whether they are constitutional. So what does the implementation of these duties look like? Specialized courts handle their specific subject matter. General courts handle anything within their jurisdiction that is brought to them and has followed appropriate channels to get there. The higher up appeals courts some court cases might have already been heard by a lower court, and if they appeal, it'll go to a higher level court, so it might go from district court to U.S. Court of Appeals, and then potentially even the Supreme Court of the United States, in which case SCOTUS is the absolute last court of appeal, and it only takes cases with a particular significance in terms of national impact or precedent setting. And usually it hears cases through what we call writs of cert, which is short for certiorari. Hopefully I'm saying that right. It's a Latin word. But basically, litigants ask SCOTUS to grant a writ of cert to review a lower court ruling that the litigant isn't satisfied with. And at least 4 of 9 justices must vote to grant that writ. Now, how does the judicial branch check and balance against the executive and the legislative? In the case of the executive branch, they can declare executive branch actions, like executive orders, unconstitutional. And they also have lifetime terms so that the president can't just dismiss judges based on politics. Although this is only for Article 3 judges. Remember, Article 1 judges have a fixed term, so they could be not renewed. They still can't just go, oh, you're out of here. But Article 1 judges have a lot less protection in that regard than a Article 3 judge does. As it is described in the Constitution, they shall serve during good behavior, which means as long as they're not impeached. And then judicial branch checks and balances against judicial branch is they can also declare legislation unconstitutional and lifetime terms so that Congress can't just follow the president in dismissing judges based on politics. So, while that is the basic rundown of separation of powers, and it is a fundamental aspect to how our government operates, there are still many challenges that separation of powers faces and has faced over time. And we talked about some of these challenges in previous episodes, such as episode 18, which focused on U.S. presidential power. But this is much more of a deep dive into the implications for separation of powers and checks and balances. So we're going to talk about several general areas where we see potential issues for separation of powers at some point in time or now. And eventually we'll get more to how some of these relate to Donald Trump. But right now, just specific, or not specific challenges, general challenges for the separation of powers. So, executive orders. Executive orders are declarations by the president that have the force of law. Individual orders are not always controversial, and they don't always impose some sort of major policy, but the most prominent ones are often contentious, at least for their time, but sometimes also further down the road. So, for example, the Emancipation Proclamation was an executive order, but so was the internment of Japanese Americans during World War II. So, you've had some unequivocally good outcomes and some unequivocally bad outcomes and some that are a bit more of a gray area. We'll get a little bit more into whether that matters, though, when we talk about the ultimate questions for separation of powers. So, some food for thought when it comes to executive orders. Is an executive order an instance of the president circumventing the power to write laws that the legislative branch has? Is he basically just saying, I'm making laws now, I'm making policies now, I don't need the legislative branch doing that? Is that what executive orders are? Does the president have the power to enforce laws if there is a quote-unquote do-nothing Congress? A lot of times, Congress gets the label of being people who just sit on their hands all day and don't do something. So if they don't do something, is the president within his rights to enforce the laws or to enact executive orders to enforce laws in his eyes and maybe in the eyes of his supporters, say they're not making laws like they're supposed to, I'm going to do it? Is that justified? When are executive orders simply enforcing laws that Congress has already made or judicial rulings that have already been made? And when is it executive orders just making laws up as they go along? Because in some cases, a president writing an executive order, they'll say, oh, well, this is actually already a thing. We're just making sure it happens. It's already been on the books, or they have a certain interpretation of a law, and their executive order enforces that interpretation of the law. So does that have any consequences for the separation of powers? Is a potential breaking of the separation of powers through executive orders good if the ultimate outcome could be considered a good thing by a significant number of people? Or is it just, under no circumstances is this okay? Well, obviously, that in large part depends on whether you think a particular executive order is a break in the separation of powers and of checks and balances. Another question to also think about: is the court sufficiently exercising its power to declare executive actions unconstitutional? For people who are very much against executive orders in general, they might see the court as the court's not doing what it's supposed to do. It's just letting the president run roughshod, or that Congress is just letting the president run roughshod. So not only is there a question of, is the president just taking power for himself? There's also the question of, is Congress and or the courts just letting them do that? Now, of course, I'm not saying that this is or this isn't the case. These are just questions to think about when you discuss the implications and the consequences for the separation of powers. These are very important questions for making sure that the system of checks and balances stays solvent. Another case where we can talk about the implications for separation of powers is war powers. So there's a debate surrounding where the Constitution vests the power to declare and make war. How much of it belongs to Congress? How much of it belongs to the president? Is there a concurrent responsibility by both? Is it just Congress that has that ability? Does the president get to take the lead on it? How much should each of those two branches be able to do in regards to declaring war, making war? For some, Congress is specifically given the power to declare war, while the president is just commander-in-chief. So Congress says, we're going to do this, and the president carries out the will of Congress in this instance of executing/enforcing the law. For a lot of these people who think that the president has very little, if any, power to declare war, they also say that the power of a president to unilaterally declare war is inherently abusive of power, and that courts have not stopped presidents like they should in the past. And if for others who think the president can and should take more of take more of an impetus. I can't think of the word that I'm looking for, but for that, think the president should have much more say in declaring war. They say that war powers are ambiguous and or vested in both the president and Congress, that the president is allowed to repel invasions of their own authority, and that Congress has willingly ceded power to the president that they should not have ceded. So these questions have also become even more pertinent with the war on terror, a matter of not just whether being expeditious or cautious regarding presidential war powers is the way to go, but what are the consequences for separation of powers? And such consequences to think about are through these ultimate questions. How much of the power to declare war belongs to Congress, and how much of it belongs to the president? Is the president supposed to just carry out the will of Congress? Does the president need to take more of a forward approach in the declaring of war? Have they already taken a lot of that forward approach to declaring war in the past, such as with LBJ in the Vietnam War, or George Bush with the war on terror? Is the executive branch or the legislative branch getting too much power on the issue? Or are they ceding too much power on this issue? Should the courts step in more than they have in the past on this issue? All these things here to really consider about what's best for separation of powers, what powers have been separated between the two branches. But it's not even though the sides have certainly argued that the Constitution clearly says this about my side, maybe it's not so clear because there's a lot of debate about what the Constitution says in regards to the declaring of war. And this, maybe more so than a lot of other cases, has particular implications for separation of powers, checks and balances, who gets to actually declare war, who actually gets to, or is it a matter of both Congress and president, or is it just one or the other? Is it a little bit murkier? That's for you to think about. Another case another matter to think about the separation of powers in is, at some points in time, presidents have sometimes disregarded SCOTUS rulings. Alexander Hamilton called the judicial branch the inherently weakest branch because it has no power to actually implement its rulings. It has to rely on Congress to write laws that adhere to those rulings. It depends on the president to enforce and execute its interpretation of rulings. For Alexander Hamilton, he says, executive branch has the power of the sword, legislative branch has the power of the purse, but the judicial branch basically has nothing like it. It has no analogous powers. It just makes rulings on laws, and that's it. In fact, much of the judicial branch's power comes from citizens' confidence in and respect for SCOTUS's legitimacy, Supreme Court in particular, but federal courts in general obviously matter, but usually think about it in terms of how they think about SCOTUS's legitimacy. And one really high-profile instance of a president ignoring Supreme Court rulings was Andrew Jackson following Worcester versus Georgia. Basically, the state government of Georgia was trying to force Native Americans, particularly Cherokees, off lands that they said were within Georgia's jurisdiction. Treaties had been made between the United States and Cherokees previously, which inherently treats them as a sovereign nation. Supreme Court basically said the state government has no authority to do that because interactions with a sovereign nation are within the purview of the federal government, not the state government. Andrew Jackson said, I don't care. Let them do whatever they want to do, because Andrew Jackson wasn't exactly a nice guy. And so the state government still pushed a lot of those Cherokees further out. So that was maybe the most high-profile instance of a president ignoring SCOTUS rulings, but presidents over the years have been accused of ignoring the Supreme Court on issues, various issues, including more recently. But ultimate questions for separation of powers here. And again, I'm not saying that those were, well, in Andrew Jackson's case, that was definitely ignoring Supreme Court rulings. But there are some murkier concepts where the president has been accused over time of ignoring the Supreme Court whenever they rule on something, or the executive branch in general just dragging their feet on things. And so that's for you to decide on, but don't want to get too much into the weeds of that, because we want to talk about ultimate questions for this disregard for SCOTUS rulings, what those mean for separation of powers, whether these actually were, in cases where SCOTUS rulings were definitely dismissed by a president or legislative branch, or whether it's an accusation that somebody feels may have been the case, but there's some debate as to whether the court's interpretation of a ruling was being carried out or wasn't being carried out. So, questions to think about. Is there ever a justification for a president to defy SCOTUS rulings? That is to say, a president thinks SCOTUS had an incorrect interpretation of the Constitution, because we don't always agree with SCOTUS rulings. Sometimes we personally think an interpretation is wrong. But if we think an interpretation is wrong, is that okay for a president to, or the Congress to also think this ruling is a bunch of crap, I'm not enforcing it? Is there ever a justification for that? Is the decrease in public confidence in the judiciary threatening the judicial branch's ability to check and balance against the executive and legislative branches? Again, a lot of that power and authority for the judicial branch comes from how we as citizens view the court. And in recent years, their legitimacy has been threatened, or excuse me, the approval of the judiciary has gone down quite a bit. So does that threaten their legitimacy, and does that threaten their ability to check and balance against the executive and legislative branches? Do the executive and legislative branches do enough to ensure the judicial branch's authority and legitimacy? How much should they be able to ensure the judicial branch's authority and legitimacy? How do you do that? All sorts of things to really consider when it comes to separation of powers in regards to how much the executive branch enforces judicial rulings and how much Congress adheres to judicial rulings when it's writing its own laws. Or how about the fact that SCOTUS nominations and confirmations, that whole process has become more partisan over time? Undeniably so. It's undeniably become more partisan overall in recent decades, more bitter and divisive. And a lot of that is traced back to the confirmation process for Robert Bork in the 1980s. Now, he was not ultimately confirmed to the Supreme Court, but a lot of that bitterness and controversy there has really, you've seen it again multiple times over time since then, from the 1980s to now. And in some more recent examples, you have a lot of bitterness and controversy regarding nomination battles, such as with Brett Kavanaugh, or Congress declining to vote on the nomination of Merrick Garland by Barack Obama when he was about to end his second term. So ultimate questions for the separation of powers in this regard is, are presidents taking too much of a lead in nominating judicial nominees, particularly those for SCOTUS? Should Congress be exercising its advice function more when it comes to advising presidents on nominees? For some people, they're really just adhering to the consent function of the advice and consent aspect that Congress is supposed to provide to the president. A lot of people would argue that Congress was much more giving much more of the advice aspects in previous times. So is Congress not doing its job well enough when it comes to partisan nominations of Supreme Court justices or federal judges in general? When Congress is controlled by the same party as the president, is Congress ceding its power to check the president on nominees? Should it be doing much more? Is it just serving as a rubber stamp for the president? And in terms of rubber stamps, are judicial nominees becoming rubber stamps for presidents when they are confirmed, thereby blurring the line in separation of powers? Because you have a lot of these unofficial, what they call litmus tests for for judicial nominees, where judicial nominees have a certain, whenever they're questioned about their views, they make clear what their views are on certain issues. And Congress obviously questions them too, but presidents, a lot of times, they will pick them based on whether their viewpoints align with the president's on various issues. And then obviously Congress will accordingly vote when the Senate votes on judicial nominees. It will accordingly vote based on whether their views are in line with the judicial nominees. So is there too much of a partisan feeling going on, which is thereby presidents and Congress are just going along with the Supreme Court nominee purely because they just think the same exact way, and going against the nominee purely because they don't think the same exact way? Are outside groups having too much of an influence in putting nominees forward for the president to nominate and for Congress to confirm the nomination of? So it's not just a matter of, it's one of those cases where it's not just a matter of whether the president is taking too much of a lead and too much power on the initiative, but whether another branch of government is basically just letting them take too much power. And then lastly, before we move on to more specifically Donald Trump and the separation of powers, is we have what's called the political question doctrine. So this is a pretty murky concept, but the basic idea is an issue is so politically charged, it's so divisive, federal courts should not hear it. And it's typically a case that involves a spat between the executive and legislative branches as to which branch thinks they have the power on a given issue. And SCOTUS, Supreme Court, expounded on this doctrine in the Baker versus Carr case in 1962. And they came up with 6 factors to determine if something was a quote-unquote political question. If there is something in the U.S. Constitution that dictates which part of the government handles the issue, if there is a judicial standard for resolving it, if there is a non-judicial policy determination that decides the issue, if the court can independently resolve the issue while respecting the role of the other 2 branches of government, if there is an unusual need to fully adhere to a political decision already made, and if there is a potential for embarrassment from multiple pronouncements by various departments on one question. So it's not a really straightforward process. Even with that criteria, what constitutes a political question is inherently ambiguous, and there's been much disagreement among both current and former justices as to what falls into the category of a political question, or even if the political question doctrine has a constitutional basis. Some justices think it's a bunch of crap anyways, and that they should rule on these issues anyways. But the ultimate questions for separation of powers when it comes to the political question doctrine to think about: does the political question doctrine allow for the executive or legislative branches to take too much power on a given issue? Should the courts step in regardless and say, this is the executive branch's responsibility, this is the legislative branch's responsibility, this is both their responsibility? Are the courts not properly asserting their responsibility? Again, we talk about how the judiciary naturally has a limited range in being able to administer their powers, whereas Congress can write laws, executive branch enforces laws. Judicial branch doesn't have that kind of power, but are they still not properly asserting their responsibility? Should they step in regardless of what the issue is? Is the political question, A, does it have a constitutional basis? And B, even if it has a constitutional basis or not, is the court not sufficiently asserting its responsibility in interpreting the Constitution in these cases? So that's just a general overview of some real key debates that deal with the separation of powers and checks and balances, and what the implications are, and it's food for thought for you to think about as to what actually upholds the separation of powers, what powers have actually been delegated to each individual branch. None of these are easy questions to answer. They don't have easy answers. A lot of people in politics like to make things sound simpler than they actually are, and the separation of powers is one such case. So it's really is a complicated matter that needs more discussion on it, especially now when we consider Donald Trump? Is his administration adhering to the separation of powers, of checks and balances? Obviously, for some people, he is. Some people, he's not. As alluded to at the beginning of the episode, we have some considerably divergent views on Donald Trump's second term in particular in terms of separation of powers, but that debate can also be applied to his first term. So for opponents, Donald Trump and allies such as Elon Musk with DOGE, which is the Department of Government Efficiency, they're overstepping the bounds of executive power, circumventing Congress, bending courts to their will. For supporters of Donald Trump, they say Trump and his allies are acting within the confines of executive power, that he needs to act more expeditiously, and that some courts are trying to infringe on his powers. So, in terms of that separation of powers, is Trump going outside what powers he is allowed as president? Is he thwarting checks and balances from the legislative and judicial branches? For a closer examination of this debate, let's look at the following three subject areas and discuss potential implications for separation of powers. Executive orders in general, which both for his first and second term, but more so for his second term. We just talked about in the last section about executive orders as a whole, regardless of president. Now let's apply it more to Donald Trump's case. Cuts in federal spending, and the end of Chevron deference. And I'll explain that a little bit more. That technically happened near the end of Biden's term. It was in 2024. But it happened in large part because of three Supreme Court nominees by Donald Trump being part of the majority decision to end Chevron deference. So first, executive orders in general. Donald Trump's executive orders. As of February 12th, 2025, Trump has signed 65 executive orders. There's a far faster pace than any president ever, including Trump's total of 220 from his first term. Now, that doesn't mean that he's going to break any records. It's just so far his pace is a lot faster in terms of executive orders compared to any other president. Except maybe a couple of other ones, maybe like FDR, because FDR also signed a lot of executive orders. And these executive orders cover a wide range of subject areas, including the southern border, cuts of federal spending by DOGE, Second Amendment, paper straws, sanctions on the International Criminal Court, and tariffs. Of course, there's a lot of other topics covered as well, but those are just some of the examples. So, the implications for separation of powers, whether they're being broken or not, consider our previous questions that we asked in the last section, and some more specifically related to Donald Trump's executive orders. So, is Donald Trump circumventing Congress to enact these laws? Or is Donald Trump simply enforcing laws that are already on the books, or judicial rulings that have already been made? Or is he just generally acting within his bounds to administer the executive branch's duties and responsibilities? Is it more just a matter of whether these policies are harmful or beneficial, or is there a real concern with separation of powers here? Is it the president's duty to enforce laws or to enact laws when Congress won't act or wouldn't act before on a situation? Obviously, that depends on whether you think Congress is a quote-unquote do-nothing Congress where they weren't doing what they were supposed to do. A lot of times, presidents on both the Democratic and the Republican sides have argued that about Congress before, particularly when Congress is controlled by the opposing party. Is Congress simply letting Donald Trump usurp the power to write laws, assuming that we believe that the executive orders are just simply writing legislation and not letting Congress do that? Are the courts simply letting Donald Trump exercise power unchecked and not declaring them unconstitutional? If the ultimate outcome of these executive orders can be considered good, is there a potential breaking of the separation of powers through executive orders? Is that potential breaking warranted if we consider the outcome good? How many people need to consider that outcome good? Or is it under no circumstances should we be breaking that separation of powers? All sorts of questions here that we really need to consider here. And I'm not saying that Donald Trump is or isn't breaking the system of checks and balances of separation of powers. These are questions to think about, and these are a lot of concerns that people have raised or have said is not actually an issue. Obviously, a large part depends on whether you support Donald Trump or not. But nonetheless, these are questions that do need to be considered. Next area to talk about is the cuts in federal spending. So these cuts in spending on federal agencies and programs has primarily happened through the Department of Government Efficiency, or DOGE for short. And that was created through a Trump executive order. And that's included firing of employees, budget cuts, canceled contracts, and cuts either partially or fully include the Consumer Financial Protection Bureau, the CFPB, USAID, Department of Education, Department of Energy, U.S. Forest Services. So, pretty wide-ranging cuts. The exact breakdown we don't necessarily know for certain, but obviously there's been a lot of news stories about what has been cut. But in any case, we need to think about what these cuts in federal spending, the implication for separation of powers. Never mind the fact that, of course, one considers the fact that DOGE was done through an executive order, so then you go back to the debate regarding separation of powers for executive orders. But besides that, some other questions to really think about. Given many of these executive agencies funding from Congress, is the executive branch essentially taking the power of the purse away from Congress by cutting programs and workforce? Since Congress has the power of the purse, they control funding for executive agencies, especially from the U.S. House, since that's where appropriations originate. Is the president basically taking the power of the purse to determine whether these executive agencies get funding? Or is it within the executive branch's power to do that because these are executive branch agencies, regardless of whether Congress has funded them? Because Congress doesn't just fund executive branch agencies, it funds all sorts of things related to the judicial branch, to the states, to local governments. So if it's an executive branch agency, is the president and the executive branch in general well within their rights to make these cuts because these are executive branch agencies? Because some of these are independent agencies where the president is supposed to have more limits on removing leadership, is the president circumventing these limits? And another question to consider, do federal courts have any capacity to limit Trump and DOGE in their attempts to make these cuts? Or would this be a matter of the political question doctrine we talked about, where something is so highly charged the courts should not step in? All sorts of things to really think about when it comes to these cuts of federal spending. It's not just a matter of whether we think this cut needs to happen or this cut should not have happened. It's what does it fundamentally mean for checks and balances? Is the executive branch going too far in its powers to cut its own agencies? And then lastly, talk about the end of Chevron deference. So Chevron deference is the principle that federal courts defer to a federal agency's interpretation of an ambiguous statute that Congress delegated to the agency to administer. And it derives its name from the case Chevron USA Incorporated versus Natural Resources Defense Council Incorporated. That was a 1984 ruling. And it concerned disagreement over a change in the EPA's interpretation of a permitting provision of the Clean Air Act of 1977. Now, the actual arguments of the case are not particularly relevant here. We're just worried about the actual result of the case, which is that Chevron deference. So federal courts basically just say the federal agency was tasked by Congress to figure out the meaning of a statute, so it's up to that federal agency to determine that. So the review process for Chevron deference, courts consider 1, Congress's clear intent in passing a law, and 2, if the courts found ambiguities in the law, whether an agency's rule was reasonably construed and not arbitrary. But in 2024, a couple SCOTUS cases overturned Chevron deference. Again, 3 of those Supreme Court justices who were part of that majority ruling were Amy Coney Barrett, Brett Kavanaugh, and Neil Gorsuch, who were, all 3 of them were Donald Trump nominees from his first term. So the courts ultimately ruled that against Chevron deference, meaning federal courts may not just defer to an agency's interpretation of an ambiguous statute. So some of the implications for the separation of powers here was, in the case when Chevron deference was intact, was Chevron deference giving too much power to the executive branch in interpreting congressional statutes? Did Chevron deference lead to the courts ceding too much of their own responsibilities in interpreting laws to the executive branch? Well, should the courts have taken much more of an initiative in that regard? And was Congress also ceding too much responsibility by having an executive branch agency figure out what the statute meant? Now, those questions, even though Chevron deference is now defunct, those are still things to consider in case Chevron deference ever became a thing again in the future. Or even though the court has ruled that Chevron deference is not a real legal concept, if executive agencies attempt to interpret an ambiguous statute in the future, might still be an issue. But in any case, with Chevron deference now defunct, has the executive branch become too limited in their power to execute laws? Do they need the ability to interpret statutes from Congress that may be ambiguous so that they can perform their function in executing laws? With Chevron deference now defunct, is the judicial branch now infringing too much on the ability of the executive and legislative branches? So there's a lot of things to really consider here when it comes to separation of powers. Separation of powers as a concept is pretty straightforward. It's the idea that the executive branch has some duties which regards enforcing and executing laws. The legislative branch has some duties which concern writing/legislating laws, and the judicial branch has specific duties of interpreting laws. So that is pretty straightforward. But in practice, how those branches actually get to perform their functions becomes a lot murkier. And when the branches are interacting with each other, is one branch infringing on another branch's ability to perform its duties in certain regards? Like with presidents with executive orders, are they infringing on Congress's ability to write laws? Or again, separation of powers isn't necessarily just about, is one branch taking too much power for themselves? Is there one or both of the other branches? Are they willingly ceding power to another branch too much? So it's a little bit of a fault going all around, not just the one who's taking too much power. If we assume that they are taking too much power, are the other branches basically just laying down for that other branch to take the reins? All sorts of questions to really think about, and hopefully I laid them out in a hopefully I made the questions themselves actually clear. The actual debate and factors in the questions are not clear, but hopefully the question itself is clear enough that you can really start to think about it yourself. And sometimes with the separation of powers, there's also a tendency for people to filter it through their partisan lens or their ideological lens. If it's a president that somebody likes, they might be a little bit more lenient on their interpretation of separation of powers. Whereas if it's a president they don't like, they might suddenly care a lot more about the separation of powers. And it's unfortunate. I think there is a lot of, and this is more of an opinion I'm talking about now. One of the relatively rare instances where I talk about my opinion, but I think there is a serious issue with people's concept of separation of powers also being too predicated on whether they actually like the president or whether they like the majority of the Supreme Court or whether they party in Congress that is a majority in one or both chambers in Congress, whether somebody likes that majority party or strongly dislikes the majority on the Supreme Court or the majority control of Congress. It's something that the separation of powers, all these questions about whether checks and balances are being upheld is one thing, but are we also letting our personal opinions about these individuals also cloud what we think about whether they are overstepping their boundaries? If we said it wasn't Donald Trump that was doing all these specific actions and it was Joe Biden, or vice versa, whenever Joe Biden implemented executive orders and instead it was Donald Trump, do our opinions change? And for some people, those opinions do shift a little bit. Maybe they don't realize it, but sometimes we let our opinions on these specific individuals dictate what we think about whether the separation of powers is being infringed upon. So just a little bit of food for thought. These are very important questions because undeniably checks and balances are a core part of our political system. But how do we best uphold them? How best do we determine how much each branch can check the other? Or what is a case, in certain cases, are they checking and balancing against one or two other branches? So just some food for thought. But anyways, that is today's podcast episode. A little bit of a longer one, but these are, when you talk about these kinds of questions, it definitely gets a little bit more into you get a lot more into the weeds and have to discuss it a little bit further. Now, so obviously love to hear what you think about all those questions, but we are going to wrap up today's episode. So as always, thank you so much for listening. I have the show notes, my Facebook, LinkedIn, my book, Why Independents Rarely Win Elections and How They Could Become More Competitive, in ebook and paperback format on Amazon. There's some other bookstores in particular, but Amazon, obviously, going to be the more well-known one. I have an educational email course, a very short series of emails on how we unintentionally, whenever we're trying to decrease polarization in this country, several of the ways that we unintentionally increase polarization and how we can correct those issues. I have the link for that in the show notes as well. But other than that, we're going to wrap things up. So, again, thank you so much for listening. And until next time, take care.